Legally Speaking with me, Tarun Nangia. Now we commence on the part 2 of our show on the topic of the emerging role of the General Counsel. What we are going to discuss primarily now is a very interesting aspect that we discovered in part 1 is why isn't this whole department, General Counsel and the team of lawyers, regulated? Why aren't general counsels on the board of a company? Why we see that in the United States, more and more general counsels are on board of companies and the office has a certain importance. I would like to highlight the example given by one of my panelists that the office of the general counsels of the GE, the General Electric, is next to the chairman's office. That is the importance of a general counsel. May I again introduce you to my panel briefly? Mr. Ryan Karanjawala is managing partner, Karanjawala and Company, one of India's leading litigation law firms. I have with me Mr. Bharat Vasani. He is former group general counsel of one of the world's largest industrial corporations, namely the Tata Group. He served there for close to 2 decades. He's currently corporate partner with Cyril Amarchand Mangaldas. And most importantly, he was part of the expert committee that rewrote the company law in India. I have with me a gentleman who represents the entire GC industry in India, in a sense, represents hundreds and thousands of GCs, Dr. Sanjeev Gebawat. He's founding member of the General Counsel Association of India, and he's the executive director and the group general counsel for the Dalmia Bharat Group, which is one of India's largest industrial groups. Welcome all of you, and let's begin. Dr. Gebawat, in the first part, you highlighted that the General Counsel and the department in India is not regulated, while it carries such a vital function. Like Mr. Karanjawala also said that a lot of promoters wouldn't be in jail today if they had listened to their general counsels well in advance. So can you, in about the next 2.5, 3 minutes, explain your idea before we can move forward?
Yeah, thank you, Tarun, for inviting me to share my views on this very important topic. Again, I would say, Tarun, in almost all the common law countries, or the most of the common law countries, the profession of general counsel is a regulated profession. And if it's not regulated profession, at least there is some certain mechanism by which the similar kind of code of conduct on rules and regulations, they would be applicable to the general counsels. India is the only common law country, or perhaps a few more, of this nature, where general counsels or in-house counsels are not regulated. So my thoughts here are in 2-3 forms. One is, if I say that the corporate India determines the economic growth of the nation, answer is yes. The corporate India contributes at 10% of the total GDP of India, $3 trillion economy, say 10% of profits, then the answer is yes. Who controls this corporate India? From a legal regulatory standpoint, from compliances standpoint, this is the general counsel. Now, this general counsel is a professional breed, which does not get recognized under any law. So when I say any law, I say that the Advocates Act and the Bar Council regulations, they don't recognize that. If I say that this is the custodian as far as compliance process is concerned, then the Companies Act or the other corporate laws, they don't recognize this. And if you notice any law in India, there are certain liabilities attached with certain positions. Like you will have those vicarious liabilities, or in the sense of that the managing directors or directors or those managers or company secretary, etc. He doesn't come under that category also. And above all, he is not the key managerial personnel as far as company law is concerned. Now, in this backdrop, we need to determine that whether this GC's profession or in-house counsel's profession should be regulated or not. From the standpoint that the corporate India is the base as far as economic growth is concerned. They would be determining the overall ethics and compliance mechanism in India. So this is one point I wanted to mention and for further deliberation. Second point, and which is very important point, Tarun, is that as general counsel, as in-house counsel, I have almost all kinds of information, but I cannot take that protection of the attorney-client privilege. Now, if I cannot take that attorney-client privilege protection, it essentially means what? I would be putting my client, which is my organization, which is my employer, at a high level of risk in the times to come in terms of litigation or otherwise. So this is second aspect which also needs to be taken care of. And for that, my my initial reaction as far as the suggestion part is concerned, that yes, the time has come that we need overhauling as far as our legislative framework is concerned. Bar Council regulations need to be amended and modified. And just one point before I conclude on this, Tarun, just see the kind of distinction which we have made. The Bar Council regulations, they give acknowledgement and recognition to a general counsel or to an in-house counsel who is working for PSUs. But they don't recognize me because I am a part of the private sector. Now, in this world, 21st century, can we make those kinds of discriminations and distinctions? Answer is perhaps no. Thank you.
Thanks for that very enlightening opening comment with good 4-5 points. I'll go to Mr. Bharat Vasani. You've served as a GC in Dow, which is an American company, and now also after that, the Tata Group. Just give us what happens. I mean, these two groups are very well known to give importance to their GCs, but could you just juxtapose of India with US and share your experiences over the years?
Bharat, you're on mute. You're on mute.
Yeah, sorry. Tarun, the American corporations have evolved significantly ahead. We are several decades behind, I must say that. In terms of the sophistication in the GC role, first of all, the GC in US corporations are entitled to attorney-client privilege. So if they give any legal advice to the board of directors of the company, it's completely protected under Section 126 of the Evidence Act, parallel legislation in US, which says it's a professional communication and it can't be relied upon in judicial proceedings. That protection is not available in India. And I had a very interesting experience of one very major arbitration that I was doing in London for telecom dispute, where the opposite side wanted to rely on one legal advice which I had rendered to the board of directors. And arbitration tribunal in London said, sorry, he's general counsel of the group and you can't rely on his professional communication because the seat of arbitration is London. LCIA rules do not allow attorney-client privilege communications to be, Mr. Salve and Daraz Khambata were arguing the matter. And very clearly, all professional communications given to me by the board to the board of directors were disallowed to be used by the counterparty. That is not the case with Indian system because India, as we discussed, that the 126 of the Evidence Act, because general counsel is, first of all, he's supposed to surrender his sanad. So he's not even an advocate under the Advocates Act 1961 the moment he takes the role of a GC. And second thing, like company secretary, every company with a paid-up capital of more than 5 crores, you require a company secretary. There is no such provision that if a company has 100 crores of paid-up capital, also you require a legal head who should be sitting on the board. Company secretary by law is attending all the board meetings and is supposed to record the minutes. So he gets that privilege of attending the board meeting. So if GC is also wearing the hat of a company secretary, he may get a chance, but otherwise not. And today, more and more corporations are going in that direction that they are creating a separate role for GC and separate role for the company secretary. Second fundamental flow is the legal education. We have large number of national law schools now. I have lost the count of number of law schools we have created. But the curriculum is primarily designed to produce lawyers who can practice in courts or who work in the law firms. And if you see, the large chunk of lawyers are being taken up in campus recruitment by these large law firms. My firm hires about 100 lawyers every year from various national law schools. Problem what happens is I find a clear trend over the last 3 years where many of the partners of the law firm are preferring to go in-house and take up the GC role. But they are not geared up for that because this training is completely different. And the quality is required to be a successful GC and quality is required to be a successful law firm partner. The difference is of chalk and cheese. There's a large number of strategic and management capabilities required in the GC role vis-a-vis a pure lawyering skills required in a law firm partner's role. So many people feel that's ultimately what? It's giving legal advice. No, it's not ultimately giving legal advice. The GC role in a corporate requires far deeper strategic thinking and process, which, managing various stakeholders, your board, your managing director, CEO, chairman, plus the large number of your clients who are your in-house people. While partners of a law firm give an advice, transaction is over, I send my invoice and my relationship with the client ends. So the difference is the approach is very transactional. That I have given this advice, I'm out of it. But when you are sitting inside the corporation, you are responsible for your advice and you meet that person whether you like his face or not every day. So note that every successful law firm partner can be a successful GC and vice versa, because the qualities required in both the roles are very, very fundamentally different. I think the Bar Council and the people who are responsible for drafting the law school curriculum should make out a clear two streams. Those who want to be lawyer but want to work in-house, this is the curriculum. And those who want to be lawyers but want to practice in courts, this is the curriculum. And those who want to work as a lawyers in a corporate law firms like doing M&A transactions, this is a third curriculum. Unless and until in fourth, perhaps we can do it for the judicial service, which is very different, which government of India, I think, is thinking now of starting Indian judicial service. But the qualities required are so fundamentally different. And since I have seen both sides of the table now, for the last 4 years, I'm a law firm partner, I can tell you that I have completely reconfigured myself. I have recreated myself, because what was required in my previous law as Tata GC and what is required today as a corporate law firm partner. So in the lunchroom of the Tata Group, I was discussing the issues of steel industry and automobile industry. Here, the reps and warranties and indemnities are discussed in partners' lunchrooms. Whether this warranty should be taken in share purchase agreement, whether this should be representation, there should be guarantee. The nature of discussion is sharply different. And I've experienced it firsthand. First few weeks, I was wondering what's happening in the law school, because everybody is discussing share purchase agreement, shareholders agreement, ROFR, tag along, drag along. Nobody is on the larger macroeconomic issues and, what is affecting telecom industry today, what is affecting, infrastructure sector, what is affecting civil aviation sector, which are the discussions you find in the corporate boardrooms. So there are very fundamentally different qualities required, and the law schools need to design separate curriculum for each of these three streams. And first fundamental principle is that recognize this profession, regulate it, make it mandatory, as Ryan suggested by amending the Companies Act, the way they made it compulsory to appoint a company secretary, you need to appoint a general counsel, and also make him liable. Today, all the laws, you violate everything. General counsel never goes to jail because he's never there as a part of the people being prosecuted. It is directors and company secretary. He's enjoying a privilege, in fact, with the fact that he's unregulated by Bar Council of India and the Companies Act gives him a lot of strategic advantage. He can give any advice, first of all, and then he's not liable for that advice. So, which is also not fair. So I think this, as a result, since there is no clearly defined role of a GC, the role differs from corporate to corporate. A role of a Tata GC vis-a-vis Birla GC or a multinational GC is vastly different. And that's where the problem is, So I think there needs to be a far greater attention to this profession than either to corporate India has ever given. And it will be better because with all this technology coming up and ESG and several other responsibilities coming up, I don't think we can continue to live in that era of, where this person is a necessary evil, is just a facilitator. He's now your business partner. He's more a strategic. In fact, I tell you, most of the modern GCs are spending far more time on public policy issues, making effective representation. If he's GC of a telecom company or an insurance company, he will represent his case before the regulators to ensure that the regulatory architecture is suiting his industry. So in fact, in the last few years at Tata's, I was spending a huge amount of time on public policy issues and also the reputation management. Today, in the social media world, your reputation built over centuries can be sullied within few hours by some tweets in the social media account against your group. Now, unless until you know or savvy how to deal with those issues and work closely with the corporate communication team, the reputation can... So reputation management is a very integral responsibility of a general counsel. And I remember how closely I used to work with the corporate communication teams at Tata's to ensure that they are given the right inputs to project the corporation in the proper light if there's something comes. So, a front page of Economic Times or something, a news item which can totally get into your stock price going southwards and everything. So it's a very, very complex kind of issue. And second thing, Ryan, one very important part which we are missing out is that with government throwing open various sectors, public, which are originally reserved for public sector, telecom, oil and gas and airports and everything, the relationship between the government and the private sector has become very complex and very intense. And still there is a trust deficit. And GC plays a very crucial role in ensuring that there's he properly represents before the government that what kind of right regulations are required for this industry. The relationship has become extremely complex, I'm telling you, over the years. And every time you meet up and reach the secretary's office, and this is the one aspect where most of the GCs are spending a huge amount of time. And unfortunately, this aspect is not recognized. This is not taught in the law school. Person requires just first-hand experience. And whenever there's a crisis in the corporation, Ryan knows some of the crises we faced in the Tata Group and how GC has to work so closely with the corporate communication team to deal with. So there are several facets of GC's role which are not even recognized by the people, that this is the role which GC plays. He works with the corporate communication team almost 50 to 60% of time whenever there is a corporate crisis, and which happens in the life of every corporate. So I wanted to say that this profession requires far greater attention, both from the regulators, from the lawmakers, from the Bar Council, from the educationists, and also from the corporate world.
Thank you. Thank you for sharing such varied and very important points and your with us. I'll go to Mr. Ryan Karanjawala. Now, you run what one can call is one of the largest litigation law firms of India. You got about 5-8 good points from Dr. Gemawat. You got about 5-8 good points from Mr. Vasani. What Dr. Gemawat said was about recognition under law, about liability, about the Advocates Act not being liable, Bar Council registration being taken away, attorney-client privilege. You saw Mr. Vasani also sharing about reputation management role, also about, of course, Mr. Gemawat also spoke about the role of GCs in other common law countries. Mr. Vasani spoke about how much time he interacted with the corporate communication team. When you listen to all of this, I want your observations from the law firm standpoint, and also the point a lot of partners angling to become GCs, law firm partners wanting the GCs role, even that also.
So, Tarun, I must compliment you and more than you, the two co-panelists I have, for throwing up so many interesting thoughts. And as we said earlier, there is as far as the GC's role in India is concerned, at the moment it is work in progress, early work in progress. A lot needs to be done. And I'll give you one example. Bharat made a very interesting point just now about regulation and industry and how important now the regulator's life with industry is, and how important it is for various sectors to ensure that they are on the right page with the legislation and with the regulation, and also ensure that the regulation that comes into force is friendly. I remember Virat Bhatia, who was the head of AT&T at that time in India, telling me one day, he said, Ryan, in America, the chairman of AT&T always has a legal background because telecom is such a regulated industry. So they realized it, that, if the man doesn't have a legal background, he will not be able to, he was the chairman, he was not just a general counsel. He won't be able to navigate the ship to the right place. So you see the role of the general counsel, the role that law regulation plays in the day-to-day interaction of society, in the day-to-day interaction of industry. And therefore, it's very important that going forward, we take concrete steps to empower, strengthen the GC so that generally things are far better handled than they have been so far. Now, one thing I have noticed as an observation over the years, increasingly in matters of litigation, there is one fundamental difference between a corporation and an individual. When the individual, in the old days, what used to happen was this, and Bharat will about say for it. In the old days, if there was a litigation, even if a company was litigating, they would go to the solicitor. And the solicitor would be the whole and sole charge of deciding who would be briefed, who would not be briefed. And, they'd say, Daddy engineer of Crawford Bailey would say, no, this is excise, my specialty. We'll go here. And a lot of decisions were outsourced to the solicitor's firm. Today, it's not like that. Today, a lot of people come and tell me, you should brief this guy more, you should brief that guy more. But my point is that our hands are, I won't say handcuffed, but they are certainly we're already in a bit of a straitjacket because corporations, councils today, because of their GCs and the vast experience that their GCs bring to fore, have already taken a decision that, look, we've done a lot of litigation with this guy, we are very happy with him, or with that chap, we had a bad experience, so we're certainly not going to him and all. So today, when we are dealing with, we started off as small-time mom-and-pop store kind of lawyers, And, we dealt with a lot of individuals in the early days. That time it was our choice, usually. Now, over the years, we see that increasingly the company, the general counsel, they come and they say, no, let's go here, let's go there. And also, I find a lot of the GCs are very well researched. They won't tell you, but if it's before a particular judge, they will give you a suggestion that, well, this is a bowler that goes better before this particular pitch, and that is a bowler batsman that goes better before that particular pitch. They won't say, but it will happen. So one thing that certainly has happened, while the GC's role, the empowerment is slow and gradual, their incremental knowledge of the handling of litigation has greatly increased. That much I find that today when you're and I always find it easier to deal with a general counsel rather than to deal with an individual, because he knows the lay of the land. He knows what is possible. He knows what is not possible. He will not make silly points. He will not ask you for stupid things. He will, you will talk at a particular level. So that is one change that has certainly happened. A lot more needs to be done. There's no doubt about it, because this is, as both our panelists have pointed out, it's a very developing field, and it really needs to be developed a lot further.
Okay. I'll take one last comment from Dr. Gimawat before we end, because you raised all these points. At the GC Association, would you like to make a representation to government so there are necessary amendments in the company law?
Yeah, Tarun, I think a very nice point, a good point. So we are initiating these steps from a government representation standpoint, and also all stakeholders, which include industry bodies as well, law firms as well. So we are requesting all these different organs in terms of supporting this and making those requisite amendments. One more important thing which I wanted to mention, because Mr. Karanjawala also pointed out on that, that the course curriculum of the university should be structured in such a fashion. You will be very happy, Tarun, and I am very happy in terms of sharing this, that we have tied up with almost most of the national law universities, and we are conducting from GCAI. We are conducting courses for the students, which include diploma courses also, and which include specialized classes also, in terms of that training and development part of it. And that tie up with various, NLUs and the public policy related some institutions as well. I think that is also helping us in terms of creating that awareness about this profession and the future prospects of this profession. So we are initiating those steps.
Thanks for that point. Mr. Vasani, would you also volunteer to help if this code needs to be amended?
Yes, sure. Yeah. In fact, I have a whole laundry list of things which needs to be amended to make this profession, is currently there in the mature jurisdictions like US and UK. And that would certainly amount to certain amount of control on the business team, because if GC says that this is a fantastic idea from business perspective, but you couldn't have a serious liability issues. Many people, GC is not necessarily the most popular person in the corporate team, because he's the one who applies the brake many times. But there are definitely specific areas where I marked out, and when the next round of amendment to the Companies Act happens, I think this is very critical that we bring up this point, because now increasingly the most mature jurisdictions have recognized this role in their statutes, and it's high time that the Companies Act of India and the Advocates Act of India is suitably amended to regulate this profession, because it's very unfair that you have such a large number of GCs across India, totally unregulated. They have to surrender their license to practice. They don't have attorney-client privilege. They have absolutely no recognition in the eyes of law, and at the same time, they have so much of responsibility. So I think it's a high time, and in fact, I have been in discussions with MCA officials many times that this is one area where the law needs to catch up with what is there in the more mature jurisdictions in the West. And also the augmenting the size of the legal teams in most companies, one of the central point, because I find that some large corporates have very grossly understaffed legal team, and as a result, they end up kind of outsourcing a large chunk of work.
So with this, we bring to a close to our two-part series on the emerging role of general counsel In fact, more than I imagined, we ended up covering a large ambit of things which a lot of promoters, other general counsels, bureaucrats would all keenly watch and follow. A lot of the legal community, the judicial community would also be interesting. So I would like to thank each one of you, Mr. Bharat Vasani, Dr. Sanjeev Gemawat, Mr. Ann Karanjawala, Managing Partner Karanjawala and Company, for sparing time and joining us on this very interesting two-part series. And thank you, viewers, for joining in. Thank you so very much.
Thank you very much.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.